Straight ahead on Law and Crime Daily, emotional testimony as the penalty phase begins for the man called the Daytona Beach Killer.
When I say best friend, that is someone that I can depend on at any time or day. I'm sorry, give me a second.
And patient care or cold-blooded murder.
My reaction was surprise that there were so many patients that were involved, and also surprised it was one individual physician.
A former ICU doctor stands trial for the murder of 14 patients. Plus, a letter from the grave now means a new trial for a Wisconsin man convicted of his wife's murder nearly 2 decades ago. But first, the death of Breonna Taylor.
You could actually see bullet holes?
I could see broken glass.
Hear testimony from an officer who responded to the scene. Law and Crime Daily, covering court cases from coast to coast. And welcome, everybody, to Law and Crime Daily. I'm Brian Ross, in for Brian Buckmeyer, who's in Kentucky covering the trial of former Louisville police officer Burt Hankison. With me in New York, of course, is co-host Terry Austin. And Terry, we begin with the latest out of Louisville, where Hankison is expected to take the stand soon as the state rested Tuesday afternoon. Earlier on Tuesday, jurors heard from another officer who responded to the scene of Breonna Taylor's shooting death. Hankison is not charged with Taylor's death, but instead stands trial on charges of wanton endangerment for firing shots into Taylor's apartment that went through the wall into a neighboring unit. It all grew out of a no-knock drug raid on Taylor's apartment back in March of 2020. Her boyfriend, believing the officers were intruders, fired at them. The officers shot back, and Taylor was killed in that crossfire. On Tuesday, the prosecution called to the stand an officer who responded to the shooting. He explained to jurors the moment when he realized the scene was not a threat.
I observed what I believed to be a window or glass door that had multiple bullet holes through it. And I thought that that was the target apartment of the search warrant that had been served.
Okay, so you could actually see bullet holes?
I could see broken glass. I believe it to be after the SWAT team cleared the actual target apartment and told us that no one was inside. We approached the broken glass.
Was that the first indication that you had that this apartment was in fact not a threat to you?
Yes.
Law and Crime's Brian Buckmeyer has been covering the trial since it began. He joins us now live in Louisville for the latest in the case. Brian?
Brian, day 4 of the testimony of Kentucky versus Burt Hankison started off with some arguments as to whether or not Miles Cosgrove's deposition would be played for the jury. Next, a firearms specialist testified. The prosecution focused on identification of a target isolation, and background target identification, all in regards to shooting at an unseen target. Cosgrove's deposition was ultimately played in 16 video clips. He explained the dangers of executing a search warrant in general. Then the deposition highlighted what information had been missing or overlooked in the planning, preparing, and executing of the warrant on Breonna Taylor's home, making it seem like the officers were ill prepared. After the deposition, Chelsea Naper, Breonna Taylor's neighbor, testified about her reaction to bullets flying through her home that was filled with her boyfriend Cody, who already testified, as well as her 5-month pregnant self and her younger son. With the prosecution resting late Tuesday afternoon, the defense's case is next. We expect Burt Hankison to take the stand in his own defense on Wednesday.
All right, well, the defense resting now. We expect Hankison will take the stand. Dina Dahl, what do you make of that? It's never an easy call.
Absolutely not. But I think partly it's because we already have a police interview of Hankison talking about that night. And he seems to say that it was dark. He couldn't see that well, yet he was shooting anyway. He needs to explain that better. He needs to say that he did it because he was defending his fellow police officer's life and that there was more intention behind it and it was not reckless. So I think that was why ultimately him and his attorneys decided to have him testify.
And Terry Austin, the judge instructed the jury that officers Cosgrove and Mattingly were unavailable to testify. What do you think that means to the jurors with an instruction that was so vague?
Well, Brian, you're right. It was extremely vague. She just simply said to the jury, look, I have an instruction for you. John Mattingly and Miles Cosgrove are not available, so they won't be testifying, and don't use that against any of the parties. She basically explained that they all requested those two to appear, but they can't appear. And so I think one of the reasons that she didn't mention it, she doesn't want the jury to hold it against anyone, so she's making it as neutral as possible. She did mention that Cosgrove's deposition would be played, and it was, as we know from Brian's reporting.
Right. And Brian, let's take a closer look at that ex-officer Cosgrove video. Did anything surprising come out of that?
Brian, it was shocking. So we already know before this that Brett Hankison was the K-9 unit there, and his dog was used for searching drugs. But in Miles Cosgrove's deposition, we found out that what they were looking for were documents, not necessarily drugs. And even the person conducting the deposition said, well, don't you think it's strange to conduct a midnight raid, a midnight search warrant for documents when you're not looking for guns or drugs? And this is one of 5 search warrants. And it kind of gave the impression that this wasn't necessary, even more so than what we believed, that the life of Breonna Taylor shouldn't be lost over trying to get documents in the middle of the night. That was shocking, and when you put it to the rest of Cosgrove's testimony, it just seemed like they had a plan, they threw it out, they didn't have all the facts and the information, and this was chaotic from the start. And it again enforces the idea of why do we lose Breonna Taylor to such a shabby, poorly constructed search warrant and execution of it.
It's all coming out, the case full of surprising. Thanks to you all. Still ahead on Law and Crime Daily, a one-time ICU doctor now on trial for the murder of 14 patients. The latest developments in the trial out of Ohio. But first, more than 20 years after the murder of his wife, a Wisconsin man is getting a second chance to prove his innocence. Our Anjanette Levy is live with the latest in the case of Mark Jensen.
Hi, this is Dan Abrams with exciting news for all of our Law and Crime followers on YouTube. You can now get the live Law and Crime Network with YouTubeTV for all of your daily live trial coverage, legal news, expert analysis, and original true crime programs. Subscribe to YouTubeTV today and then locate Law and Crime in the channel guide. And for only $1.99 a month, you can add the network to your bundle. Watch Law and Crime every day with YouTubeTV. We put you in the jury box.
And welcome back. A Wisconsin man serving a life sentence for the murder of his wife is getting a new trial because of a letter from the grave. This after the U.S. Supreme Court refuses to hear an appeal by prosecutors. Law and Crime's Anjanette Levy is here now with more about the case that's garnered national attention. Anjanette?
Brian, Mark Jensen's appeals have been heard by state and federal courts since his conviction in 2008. Now, more than 20 years after he was convicted of murdering his wife, he is getting a new trial. Jensen appeared in court in Kenosha County, Wisconsin, with his lawyers this week. He has always maintained he did not murder his wife, Julie, in their Kenosha County, Wisconsin home back in 1998, and that she took her own life and framed her husband. Prosecutors say Mark Jensen poisoned his wife with antifreeze and smothered her because he was angry about a brief affair she had had. At Jensen's new trial, prosecutors will be barred from using a letter that Julie Jensen gave to her neighbor in which she wrote that she would never commit suicide and that if she ever died, it was because her husband killed her. The argument over this letter went all the way to the U.S. Supreme Court, which decided not to hear the case last week. The Wisconsin Supreme Court had already said that prosecutors using the letter and voicemails that Julie Jensen left for a police officer violated Mark Jensen's right to confront his accusers. Interestingly enough, the judge who allowed that letter and the voicemails into evidence was Judge Bruce Schrader, who presided over Kyle Rittenhouse's trial last year.
There's a small segment of the community that thinks he's innocent. There's another small segment that throw around conspiracy theories about Julie framing her husband and then committing suicides. I mean, there's all those things, accusations that come with a case like this. But I think the vast majority of the community thinks that due to the evidence, even above and beyond the letter from the grave and the voicemails, that there's enough evidence to say he's guilty.
A new judge is actually assigned to this case at this point, and a motion hearing is scheduled for November of this year, and then the new trial for Mark Jensen, is scheduled for January of 2023. Brian?
Thanks, Anjanette. Let's bring back co-host Terry Austin and legal analyst Dina Dahl. Dina, the murder in this case dates back to 1998, more than 20 years before the new trial is set to begin. What kind of difficulties does that present for either side?
I mean, it definitely presents difficulties. Some of the witnesses may have passed away. Memories may have, they've forgotten things in the meantime. And also the emotion of the witnesses, of people who were connected to the victim, that's, passed as well, in terms of the prosecution case. But I also think in these 20 years, society has gotten a lot more awareness around domestic violence cases. And so that could help the the prosecution.
And Terry, if the prosecution is barred from introducing the so-called letter from the grave, how do they build a case?
Well, certainly that letter made it easier, Brian, but if they're not able to introduce that letter, they're going to need to focus on physical evidence, and they're going to have to get witness testimonies. And Dina's right, there won't be that many witnesses around. But as far as the physical evidence, I think the medical examiner is going to be very important. One of the things that we know is that she was poisoned and that she suffocated. The medical examiner is going to have to focus on that suffocation, because you cannot suffocate yourself. Your body is going to immediately respond to that and stop the suffocation. So I think if they focus on that medical, if they get witnesses in who can talk about what they knew at the time, and then of course the defense can always cross-examine, I think they might be able to prove the case.
And Anjanette, this case seems to be full of surprises, unusual developments, conspiracy theories.
Most definitely. And, lots of conspiracy theories out there, and a lot of people, some people actually in the community, thinking that this was some sort of plot by the wife. But then there are a lot of people who think that Mark Jensen was guilty. So this is actually the third judge handling this case, Brian. The second judge assigned to the case actually reinstated the conviction after a new trial was ordered. He did that without a new trial. And then, of course, that judge was overturned as well. So this is a case that's got a very long history with a lot of twists and turns.
And we'll follow it closely here. Thanks very much. Coming up on Law and Crime Daily, the so-called Daytona Beach serial killer facing a possible sentence of death for the murder of 3 Florida sex workers. Plus, end-of-life passionate care or murder? We head to Ohio, where an ex-ICU doctor is on trial for the deaths of his 14 patients. We head now to Ohio for the latest out of the trial for William Husel, a former ICU physician charged in the murders of 14 patients, all of whom prosecutors say died because they were given excessive amounts of fentanyl while being treated. So far, testimony for the state has consisted of pharmacists, ICU doctors, and other medical professionals who work with Husel at 2 of the Mount Carmel Hospital branches in Columbus, Ohio, between 2015 and 2018. The jury has heard testimony about fentanyl dosages and the amount an expert says led to the patient's deaths. A pharmacist who worked at the Mount Carmel West branch testified Thursday, saying Husel, was named in risk management reports for using high doses of fentanyl. He also told the jury about a night pharmacist who expressed concerns over the dosage being administered to patients.
I directed him to contact our quality and risk management individual, Katie Barga, and alert her that we had a concern and that we needed to look further into it to find out the circumstances of it, so that we would know if it was a serious problem or just a general report. In my capacity, I often heard people would come and tell me they have a concern about a particular drug or whatever, or the use of the drug. And So normally the first thing we have to do is get more information on it and understand why the doctor prescribed it and what was the patient's circumstances before we move into a larger investigation.
So Terry Austin, based on the testimony of the pharmacist so far, how does it shape up in terms of Husel and whether he violated any protocols?
Well, listen, Brian, so far it does seem like he's violated protocols. First of all, he's using prescriptions that most people don't use. Most of those doctors prescribe morphine versus fentanyl. And the fact that he used such high doses. So it does seem that he's going above and beyond what the protocols are. But the best physician who was up on that stand, he was actually a pharmacist. It was John O'Connell, who we just saw. He was very impactful. He basically was the director of pharmacy at the time. And he said he was concerned about the fact that the amount of drugs was so high, there were so many patients, and it all came down to this one physician. And so I think he was very clear that there was something really wrong here. And he also made it very clear it wasn't the job of the pharmacist to prescribe. It was the job of the physician. Very damaging testimony.
Indeed. Dina, this case is scheduled to last at least eight weeks, and it's weighed down by heavy medical testimony. Should there be a concern by both sides about the jury's attention span?
Yes, and that's something attorneys always take into consideration. I mean, serving on the jury is very important, but it's also a sacrifice, and they try to be cognizant of using that time. But there are 14 murders here. The prosecution has to prove each one. That is just going to take a while. And although it drags it out maybe in terms of the juror's mind, it also becomes much more persuasive that his actions weren't just a coincidence, because we're going to see a pattern. He is going to have done a very similar thing in each of the deaths. So ultimately, that cumulative evidence helps the prosecution quite a bit.
An 8-week trial. All right. When we come back, the courtroom gets heated as the penalty phase continues for the man called the Daytona Beach serial killer. Why did convicted killer Robert Hayes clench his fist in the courtroom? That's still ahead on Law and Crime Daily. And welcome back. The penalty phase is now underway for the so-called Daytona Beach serial killer, just 1 week after Robert Hayes was found guilty on 3 counts of first-degree murder. Hayes was convicted of killing 3 women investigators say were sex workers in Daytona Beach, Florida. The killings happened between 2005 and early 2006. Investigators linked Hayes' DNA to the 3 shooting deaths after the murder of a 4th woman, Rachel Bay, in West Palm Beach 10 years later. Hayes faces separate charges in Bay's murder and will be tried for that at a later date. On Monday, the penalty phase began for Hayes, who now faces the death penalty. Jurors heard testimony from Hayes' mother, sister, and college best friend, who broke down crying while speaking to attorneys.
I'm actually Robert's daughter's, his first child's godfather. So when I say best friend, that is someone that I can depend on any time or day. Sorry, give me a second.
Later, Hayes himself gets visibly upset in the courtroom when the defense shows a picture of his daughter.
It's very upsetting. I made it very clear that I'm not one of my children. Okay. Viewed or showed any of this, especially since it's been shown on YouTube and on this channel. And again, there won't be any violence, nothing like that. I'm just very upset at that fact.
Well, I saw you clench your fist, and that caused me some concern.
I apologize.
All right, Gina, that was strong testimony from Hayes' best friend, powerful, emotional, but was it enough to take the death penalty off the table?
Probably not. I mean, we reserve the death penalty for the most egregious crimes. He is convicted now of killing 3 women, so he definitely qualifies for it. That evidence did show his character, that this was maybe unlike his character, and also maybe to have some compassion. His sister spoke about how difficult it was to grow up in their house and how he was molested as a child. All those things the jury will take into consideration, that maybe he should be in prison to allow some sort of redemption, that there may be some kind of compassion and hope for him. But ultimately, this is the kind of case that if you want to apply the death penalty, it would be in a case like this.
Terry Austin, the judge, as we heard, said he saw Hayes clenching his fist. Do you think the jury's getting a glimpse of his temper?
Well, maybe so. I really wonder if they saw it. I was watching the trial intently. I did not see him do it, but the judge absolutely did. It was a very interesting moment. The judge literally stopped the proceedings. He said during Dr. Wu's testimony, let's pause. And Dr. Wu actually had a PowerPoint where he was showing all of the causes as far as why Hayes may have behaved the way he did. And he showed a picture of the fact that his daughter has autism. And when that picture showed, that was when Hayes clenched his fists. That was when the judge said, let's stop the proceedings. At that point, counsel apologized and said, listen, I didn't mean to put the picture in. And at first, the judge basically said, well, Mr. Hayes, if you want to leave the room, you can. And then Hayes explained, no, I don't want that picture to be shown. And so I think the judge understood at that point that perhaps they shouldn't show the picture. And they did allow Dr. Wu to continue testifying without showing any other pictures in that PowerPoint. But if the judge saw that, Brian, I really do think, or rather if the jury saw it, I really do think it's going to influence their opinion.
Absolutely. Of course, they get great latitude in deciding the death penalty. Any one person can knock it out. Well, thank you all for joining us. We appreciate it very much. We'll see you next time as we continue to discuss justice in America.